actually, what's interesting about them is there's a couple places where they're actually in conflict, and then they've also got this whole set of bar standards that are ostensibly specific requirements for particular forms of advertising that are by default assumed to be against the rules. And again, the state of California is trying to conform these two sets of rules and also conform them more closely to the ABA model rules. But it's really a telling example of how hard it is for a state to try to offer direct guidance when the forms of communication are changing so quickly. In the state of New York, New York is one of the states. The states out here in the West tend to be pretty open. They're not terribly restrictive when it comes to attorney speech. It's not so much the case on the East Coast and in the Southeast, where there's been a lot of reaction from the attorney regulators about what's perceived to be the excesses of attorney advertising. So in the state of New York, for example, there were a series of rules that were imposed on attorney advertising a few years back that prevented all sorts of very commonplace advertising techniques. And it was really in reaction to a personal injury law firm in upstate New York that did a series of basically tongue-in-cheek television ads. But they called themselves the Heavy Hitters, which is actually a franchise name that a lot of law firms around the country use. But they also did a series of ads that showed them defending aliens in an alien spacecraft accident case, or walking as a giant through the streets of downtown Syracuse. And the state put in place all sorts of restrictions on, there was one that specifically prohibited the use of attributes in an advertisement that have nothing to do with the practice of law, such as gigantism or the ability to breathe oxygen without a space helmet when defending an alien on an asteroid. It was a little bit ridiculous. And to their credit, this firm filed a lawsuit in federal court, and they won. And the state pushed it as far as they could. And interestingly, the state of New York took the position that many of these advertising techniques had no protection under the First Amendment. Really a pretty shocking position for the state to take, and particularly for attorneys to take, which was really given very rough treatment by the courts, which slammed the state and permanently enjoined most of those rules, both at the district court level and at the circuit court level. The state tried to file cert for it, but that was not surprisingly denied. So those rules, although you can still find them on the books in New York, have largely been the most excessive of them, including this restriction on these very commonplace advertising techniques, a restriction on the use of testimonial advertising. Those have been pushed to the